Calvin Green versus Alicia Green. Mr. Green, this is your pairing time complaint, is that correct?
Yes.
You're indicating you did not get your summer pairing time, is that right?
Correct.
Okay. And so how did that work? Did you go to pick up the child and the child wasn't available?
This started back in like April. That I tried picking her up. She wasn't there, but then she had like a medical problem. So I kind of like, okay, get better. And then we haven't gotten back together really.
All right, well, did you have conversations with Miss Green about it, or did you go to the pickup location? So when your pairing time starts, you do the pickup, is that correct?
Yes.
Right.
I used to pick her up from school. But during summer time, I'll go to her, her house, pick her up.
All right. Did you go to her house to pick her up in the summer?
Guys, today we are going to watch a father walk into court claiming he was denied summer parenting time, only for the judge to reveal the truth.
Not at that time, no, I did not. Because I've already tried at the school like 5 times, and then there was no success. So, and then I asked her, when am I going to get to see Elodie again? And I didn't get an answer.
All right, now school has started. Have you tried pickups since school has started?
I've asked them if I'm going to get her this weekend, and I'm sick.
All right, Ms. Green, what would you like to say regarding this matter?
I haven't denied him the parenting time because, as a remote worker, I've made sure that Elodie's been, consistency available for visitation. I have not seen him show up to attempt to pick her up. I have not heard from him in that regard. We did attempt mediation on Monday in which my daughter was present, but we were unable to, reach a solution.
Well, a solution on what?
On anything, on coming up with a new parenting time schedule, because, at this point in time, besides the fact that he has not attempted to, pick her up that I'm aware of, that he's had minimal communication with my daughter over the past 8 months. And, at this point in time, it sounds like Elodie is, refusing to comply with the visitation order. And, all I can do is encourage her.
What is his pickup supposed to be during the school year?
He picks her up after school.
Okay.
On every other Wednesday and every other Friday.
All right. Did you guys make that in order at some point? Because I know the judgment of divorce indicated Fridays no, it's just Friday after school. Okay. All right. So when is your next weekend, sir? The two of you have an order that you're supposed to have parenting time every other weekend during the school year, correct?
Correct. My last one I missed was on the 12th to the 14th, so then it'd be the every other one past that, which is 26th and 27th.
Okay. So on the last one, on that Friday, did you go to school and attempt to pick her up?
She wasn't there.
Okay. Miss Green, was she not in school on Friday last time?
I believe she was sick that day and homesick.
Okay. So when she's sick, does he come to your house to do pickups? Is that what you've traditionally done?
Yes.
Okay. So I run into the issue here, Mr. Green, is, you file this complaint, but everyone agrees that you didn't attempt the pickup during the summer. So I can't find somebody in contempt if you're not showing up to pick the child up. If there's a statement of, hey, the child's not going to go with you, that's still technically not enough. I mean, you need to show up, and if the child's not there or made available to you for pickup, then you have a potential complaint in the future that I can exercise and find somebody in contempt for or address. But given what happened over the summer, I am going to dismiss the show cause against Miss Green, as it does not appear that you were making the attempts to go there. I understand that maybe you thought she wasn't going to be made available, but you have to actually make the attempt. So it sounds like this Friday is your parenting time. Is that correct?
Yes.
Okay. So obviously, if you go to exercise your parenting time this Friday and the child's not made available to you, then that's an issue for a parenting time violation and contempt. But at this point, I'm not going to find any contempt given the information that the pickups were not attempted. Do you have any questions regarding that, sir?
I guess not.
Okay, Ms. Green, any questions?
No, thank you, Your Honor.
All right, so it sounds like his next weekend is this weekend. If she's not in school, then the pickup would happen at mom's house. All right, thank you both for appearing. You're all set. Okay, it does appear we have the parties in the next matter present, so I'll call the matter of Brittany Burr versus Tyler Nash, file number 15-157.
Your Honor, for the motion
Is there anything
regarding,
else that you had filed, Mr. Nash? Was there anything?
no, Your Honor, in the motion regarding support, I had some issues with, having Miss Burr served. I had mailed it out and it got returned back to me, and I'm working with friend of the court on how to resolve that currently.
All right, what is your request regarding support?
Just that now the parenting time has changed, so it is equal 50-50 week on, week off for both my children, whereas before it was only with my oldest son. So just asking.
All right, I do see there was a prior order indicating 182 and a half overnights with one child and 104 with the other, and you're saying it's 182.5 now with both children?
Correct, Your Honor.
All right, Ms. Burris, do you agree or disagree with that?
Yep, whatever the amounts of overnight that it was stated in there with Wyatt. Yep, we're doing the same with Walker.
All right, so you're sharing equal time with both children?
Yes, sir.
All right, so we'll do a new support calculation based on the equal time going back to his filing of that motion.
When
And then
was it filed? Sorry, sir.
It looks like September 5th.
Okay.
And then Mr. Nash, you had some parenting time complaints, is that correct?
Yes, Your Honor. I believe there is 4 complaints. I'm not sure if you want me to go through those one by one or kind of give you a
Yes, sir.
Sorry.
All right, let's go through them.
Okay. So there's been, I have 4 complaints here. The first complaint I'll bring up is the alleged violations would have been 12/9 of 2024, 6/28 of 2025. Just refusal to communicate about medical and governmental appointments. For the governmental appointments, Ms. Burris got both my children enhanced IDs without my consent. Didn't tell me about the appointment. She also made a counseling appointment and didn't put it we're ordered to use the Our Family Wizard app, Your Honor, and she didn't put it into the calendar until after my son had told me about it. Signed up for, my son was signed up for baseball, didn't put in the events into the calendar until 2 weeks after practices had started. And we've had those issues for baseball and most sports every year. Been trying to resolve it through multiple mediations. And in our February 11th mediation agreement, which became an order, there was a clause in there that to have clear, direct answers, and Mrs. Burris still is kind of vague with that, like she's refusing to do that, and even in her response to that complaint, she never addressed whether or not Walker, my youngest son Walker, got an enhanced ID or anything like that. And she's still, making appointments last minute. It almost feels intentionally, that she does that sometimes, so that I am not able to attend or be included in that. I have another complaint for, not informing me about my son's school forms and the alleged violations are on May 7th of this year and June 11th of this year. And, around June 11th for this complaint, reached out trying to discuss Walker's class selection for it would be now this year, since he's going to be taking some high school credits. And let's see, the counselor emailed me a signed form where Miss Burris had that, and it went home on May 7th. And when I asked Miss Burris about it, she didn't give me a response. And
a frustrated dad accuses his ex of keeping him in the dark about his kids' medical visits, school updates, and sports.
It was brought up during a conversation on June 16th about missing information for Wyatt Summer. During a conversation on June 16th about missing information from Wyatt summer camp. I had to ask that multiple times.
So I'm going to pause you for one quick second. So what is your request as far as what are you seeking from the court for these alleged violations?
Your Honor, this has been kind of one of those things where it's been going on for many years, and I don't always file complaints because I'm not a big fan of going back and forth to court. But it seems the only time that she stops is when I file a complaint, and then she stops for a short amount of period of time until after court. And then, you give it a couple months after court and she's going back to doing the same issues.
Are you requesting that she be found in contempt and fined, or what is your request?
Just some sort of a consequence so that this behavior stops from her. So.
Okay. If that's the case, then what we'll have to do is set the matter for a evidentiary hearing.
Okay.
Unless you agree that you violated the order. If not, then what we'll do is set the matter for a evidentiary hearing.
I don't agree that I violated any order.
Okay, so we'll set it for a hearing. It's going to be an in-person evidentiary hearing to determine whether or not the order was violated, and then whether or not there should be any contempt sanctions. I have availability on October 29th at 11 a.m. Do either of you have any conflict with that date?
I'm pulling up my calendar right now, Your Honor. Sorry.
Sure.
I believe I'm open for that. You said 11 a.m., Your Honor?
Yes, sir.
Okay.
Ms. Burris, any issue with that date?
No, I don't.
All right, so we're going to set for a in-person hearing on October 29th at 11 a.m. If you wish to call any witnesses to support your side, you need to file a witness list. If you wish to introduce any exhibits, you need to file an exhibit list. Those have to be filed at least 14 days prior to the hearing date. Additional information will be provided on the notice, as well as you could potentially get some standard forms from the front of the court if you need them to complete those documents. Any questions, Mr. Nash?
No, Your Honor.
Ms. Burris, any questions?
No, sir.
All right, thank you both for appearing. I'll see you October 29th.
All right. Thank you, Your Honor.
Well, I'm going to indicate also, so I didn't realize that support motion that you filed, Mr. Nash, was actually noticed up for November, but since there is an agreement that the children are have equal parenting time right now, We will make that new support recommendation, and that hearing in your motion for November 5th would be canceled, okay?
Okay, thank you, Your Honor.
Thank you. It's a matter of Lisa Tabaka versus Kenneth Tabaka, file number 22-19040 DM. Do we have the parties on that matter present?
Lisa Tabaka is here.
Thank you. This matter was set for 9:15. It is now 9:20, so I will proceed. And Ms. Tabaka, this is your motion, is that correct?
Yes, Your Honor.
You're looking to make a change in pairing time?
Yes, I would like both of the kids to be able to have a say on where they want to go. On August 28th, after Carly had a behavioral emergency and had to go to ER, her dad has been allowing her to make the choice on where she wants to go, like if she wants to go to his house for the weekend or my house on the weekend. And during the last month, she's only gone over there one night, one overnight, and the rest have been dinner nights. And
All right.
I would
And
like-
have the two of you reached any agreements on this issue?
he will let Carly make a choice, but he won't let Luke make a choice. Luke will be 10 in October. And when I try to ask him about it, he just says that Luke has to be 14 and he's gonna pass on this right now.
All right, so to make any changes, I do have to have a hearing unless there is an agreement. So what I have to do is set this matter then for a in-person evidentiary hearing
Okay,
with interviews of the children. Guess I'm trying to decide if 1 hour is enough or if you think we might need more time than that.
maybe a little bit more because I want to ask if their family physician and their counselor could be a witness.
You're free to bring in whoever you want as a witness.
Okay,
So if we going for a little bit more than an hour, we'd be looking at, well, maybe I'll start with an hour because, obviously he's not present. I guess he'd show up for the actual evidentiary hearing, but I can't be guaranteed. So I'm gonna give you an hour to start. If we need a little more time,
Okay.
we'll scramble and get you additional time or run over the lunch hour a little bit. So I'm gonna set it for November 5th at 11 a.m.
okay,
The kids should be here at about 10:45 for the preference interview. And again, that's an in-person hearing. You do need to file witness and exhibit lists 14 days prior. That information will be provided on the notice you are going to receive. Any questions, Mr. Baca?
no, Your Honor.
All right, thank you for appearing. You are all set.
Thank you. Have a good day.
Thank you.
Your Honor, Mr. Tabaka just appeared in the waiting room, so I'm going to bring him in if you would like to tell him or.
All right, hold on, Ms. Tabaka.
Okay.
All right, Mr. Tabaka, I think you're joining our room. We have started your hearing on time about 8 minutes ago. We were just wrapping up. If you could please unmute and I can give you the information.
Okay.
All right, can you hear me okay, sir?
Yes.
All right, so there is a request to make some changes to the parenting time. Are you aware of those requests?
I am.
All right, are you in agreement or disagreement?
Disagreement?
All right, so we're going to set the matter for a in-person evidentiary hearing. You weren't here, so I originally set it for 1 hour on November 5th. Do you
Okay.
intend to call witnesses or just provide your own testimony?
Provide testimony?
All right, so I think we'll stick with the 1 hour. So do you have any conflicts with November 5th?
One moment, please. I do apologize for being late. I'm in the UP for work today. Services spotty. No, November 5th is fine.
All right, so we'll proceed forward with that date. You will get a copy of that notice also. Witness and exhibit lists need to be filed 14 days prior. All right, thank you both for appearing. You are all set.
Thank you.
Thank you.
Of course, going to call the matter of Jason Jantunen versus Amber Benara, file number 25-20066 DC. If council could please place their appearances on the record.
Good morning, Your Honor. Brooke Robinson appearing on behalf of plaintiff Jason Gentinen.
Good morning, Your Honor. I'm sorry. Paul Valak is appearing on behalf of Amber Manara.
All right, looks like we have dual objections to the FOC's child support recommendation. Ms. Robinson, as plaintiff, I'll ask you first, what are your objections?
Yes, Your Honor, thank you. We looked at the recommendations and we think that we need a deviation on the medical side of it. I understand that defendant may be challenging the medical plan and everything, but looking at ours, we have a fully funded HSA, zero cost of premiums because my client's employer pays the premiums, but we have a fully funded HSA, which means there are zero out-of-pocket costs for him or for Ms. Manara in taking care of the children's medical needs. So we are seeking a deviation on that side. I will also bring up the concern that that there's a possibility that the information is a little bit skewed as well, as our ice storm this year had Mr. Gentinen very, very busy at work. So there is a considerable amount of overtime and double time that is reflected in his pay stubs that will not be a norm, that we're concerned may have skewed the results of the calculations.
Thank you. Mr. Vlachos, what are your objections?
Essentially, our objections are my client believes that the health plan that she has, which is a low deductible health plan, also includes full orthodontia coverage, should be considered, and we need to do a little more fulsome evaluation as to which one makes more sense for the parties. Additionally, my client is maintaining some seasonal employment to the tune of about $1,800 a year that is going to end. Additionally, there are some union dues of approximately $90 a month that are going to have an impact going forward that were not reflected. So those are essentially our objections. I think it centers around the health issue, though.
Okay. All right. Well, the child support manual is pretty clear on the steps to take to determine an appropriate plan. Obviously, we don't have time to do that in a short hearing today. So what we'd have to do is set all these objections for an evidentiary hearing and take testimony on all of these matters. Counsel, do you think we can get that done within an hour?
Yes, Your Honor, I think that would be fine.
Okay.
Sure.
All right. Are you available November 12th at 11 a.m.?
I am.
That looks fine.
And Mr. Vlachos, are you seeking permission to appear by Zoom for that?
That would be, I think, good if we could, unless it would be more advantageous to have us in person. It really doesn't matter to me, Judge.
It's much easier if we got, exhibits coming in and that type of thing.
Yeah, we can do that in person. And of course, Ms. Robinson and I think could endeavor to see if we can't sort this out in the meantime.
I imagine.
That would be great. Okay, so we'll set it for November 12th at 11 in person. If we are moving forward, you do need to file witness and exhibit lists 14 days in advance. And counsel, it gives you some healthy time to have some discussions and see if you can't come to an agreement. If you do, just let us know, okay?
Great. Thank you, referee.
Thank you.
Thank you. And Mr. Baker, this is your objection to a child support recommendation. Is that correct?
Yes, that is correct.
All right. And what is the basis of your objection?
Just hardship and past record of payment of all child support in my history. And I just wanted to know if I could lower it than what the amount was calculated by a friend of the court.
All right. Do you have any objection to the way the calculation was done?
I haven't seen the calculation, so I guess I don't have any objection other than this was a method to possibly reduce it.
All right. So the key is whether or not your income is correct is the first an important step. So are you objecting to what they used as your income?
No, I'm not objecting to anything that was entered into to be used by the calculation. I'm just asking for hardship
Okay.
due to some extenuating circumstances in the present.
All right. I do see, it looks like you got some bills coming up here and payments to make. Is that what you're indicating?
The judge steps in, scheduling interviews with the children to hear their voices directly before making a ruling.
Yes, severe, quite large, the IRS, and also I applied for Social Security. I turned 62 in May, and I've been denied Social Security due to my income is too great based on the threshold for that. And I've not received any Social Security since, not one payment. I did have a pension that ended on my 62nd birthday due to the fact that I would be able to collect Social Security. Right now, my impression, based on what I met with Social Security last week, that October would be the earliest payment, but I have no guarantee. That's approximately $2,500 a month that I'm not receiving for May, June, July, and August. Now it's been 4 months. That's part of the
What
hardship.
is your income now?
My income right now is full-time at Menards, and it's roughly $34,000 annually.
Okay.
And that also, go ahead.
I was asking in front of the court if that's what they use to calculate your income.
We did the average
Correct.
of quarterly wages, which indicated for quarterly would be $9,541.46, which
Okay.
would equal about $3,100 a month.
Okay, so that was the Menards information that you used?
Correct.
All right. And sir, you continue to have that job?
Yes, I am still employed.
Okay, all right. All right, anything else you want to say, sir?
No, not this time.
Then it's my understanding perhaps one of the children turns 18 or has turned 18 and that's going to change the support amount starting next month. Is that correct, friend of the court?
Yes.
Okay. You understand that, sir?
Yes, I do. I've been given written notice as to the new amount, and that's what
Okay.
I objected to.
Okay, all right. Miss, looks like it's Brinker now. Anything that you'd like to say, ma'am?
Yeah, I have looked up to see if he had, actually, I did contact him to see if we could mediate it, just to see what he thought would be a suitable amount. And I reminded him that he is responsible for 50% of extracurricular activities and extraordinary medical expenses, of which I've never charged him for, I guess you want to say, just because I know that he is struggling financially. So I haven't charged him for that, but also I did look up the qualifications for him to be able, it requires a significant change in circumstances to be able to deviate from the child support formula. And the IRS issues aren't enough. Tax problems are considered to be a personal debt. Or money mismanagement, of which Mr. Baker has a degree in finance and was previously a global property tax manager for a Fortune 500 company. So again, the IRS issues are like his choice, not an involuntary reduction in income. And his home repairs that he cited on his complaint also, the roof repair is considered a normal living expense. Ordinary maintenance such as the roof doesn't count as a substantial change either. So and again, our son turned 18 last week. So again, he's going to be dropping off. So the minimal amount that he will be paying me going forward, maybe $100. I think it's like around $100, maybe $120 a week, with, the cost of living these days and the fact that he doesn't contribute anything extra. I feel that the child support calculation is a fair amount.
All right, thank you both for your input. I have reviewed obviously the file, the objections, heard comments from both parties, reviewed the child support formula manual. I don't believe the suggested deviation reasons are an appropriate reason to deviate, so therefore I will deny the objection. You both have the right to file an objection to my recommendation within 21 days. That information will be provided on the paperwork you received from the front of the court. Thank you both for appearing. You're all set.
Thank you.
All right, court calls the matter of Shelby Spreeman versus Ross Spreeman, file number 25-19976DN. If council could please place their appearances on the record.
Good morning, Your Honor. Elliot Blumberg on behalf of Shelby Spreeman.
Good morning, Your Honor. Brooke Robinson on behalf of Ross Freeman.
Thank you. And Ms. Robinson, we're here on your objection to a child support recommendation. Is that correct?
Yes, Your Honor.
All right. What would you like to say regarding that?
Okay, so we've got two tiers in this calculation that has differing payment amounts. Our concern is that during this entire time, my client has not had the children and the plaintiff has been living in the marital home exclusively. We feel it would be a bit of a double dip during that period for my client to be paying all the expenses of the marital home and supporting the children that way, as well as taking a child support payment from him as well. And we do understand that there's a possibility that the plaintiff has vacated the home. We think that the effective date of child support should be set at that date. However, we have not heard when exactly that has happened or is to happen. We've reached out to plaintiff's counsel. I believe we are trying to negotiate that, but we are looking for some sort of response on that as well. Moreover, we do also note that there has been a significant debt accumulated during this marriage that my client has been solely responsible for during this period. And obviously that debt will have to go into consideration as they divide it upon the divorce as well.
The divorce itself is not final yet, is that correct?
Right. Correct.
All right. On those issues, Mr. Blumberg, anything you'd like to say?
Sure, Judge. First of all, Mr. Spreeman has paid no child support either directly or indirectly to my client since this action was commenced in February. He has been making the mortgage payment, and pretty much that's the only debt that he's been paying. My client has in fact vacated the property on August 16th. Mr. Spreeman is free to re-enter the property once my client gets the remainder of her personal items. Again, he hasn't paid any support at all. So I think that this objection is really misplaced. The fact that there's debt in this marriage is of no consequence as it relates to his child support obligation. Again, he's paid no money directly to my client to help support these kids.
Was there ever any order by the court regarding payment of the mortgage or anything along that line?
It's what the parties basically agreed to. There is no order that I'm aware of that requires that.
And Ms. Robinson, was there any order or any agreement by the parties regarding?
My client tells me there absolutely was no agreement, Your Honor, and I don't believe there was any order. However, my client has noted that he has paid at least $1,500 up to this point to plaintiff to assist with support.
There have been no payments since June, as I understand it.
All right, so this order looks like tier 1 went into effect June 25th, and there was a second tier beginning in September. Do you have any other objections to the recommendation, Ms. Robinson?
No, Your Honor, thank you. Oh, yes, I do, Your Honor. The daycare portion of it, I apologize, the childcare portion, we have reason to believe that the childcare expenses may be a little bit inflated. Defendant believes that based off of what the childcare provider had provided to him, she had zero expenses for childcare. So we were questioning that in the calculation as well.
Okay. Mr. Blumberg, does your client receive any sort of childcare assistance?
He is, Judge, and all that information is certainly available to the defendant. DHS is paying for daycare. My client doesn't even know the exact amount of what that obligation is. All of that stuff is discoverable.
So childcare was calculated in the recommendation, is that correct?
Yes.
Okay. So does your client, Mr. Blumberg, have any out-of-pocket for the childcare, or is all that covered?
I have a food portion I have to out of pocket.
For daycare, no, there is a food portion which he has to pay out of pocket.
All right, so her daycare though is covered.
Yes,
But is she paying food to the daycare or
yes.
is she? Okay. All right, is she able to provide that information then? What that
Again,
amount is?
I'm sorry, I didn't mean to interrupt. My understanding is that she doesn't get billed directly. Do you for the food? Okay, yeah, so that stuff is available.
Okay. All right, Ms. Robinson, anything you want to say regarding that?
No, I'd like to see the numbers. But I think
All
we
right.
can do
So it
that.
sounds like we need to, review the daycare expense, or childcare expense, because it looks like there was a pretty healthy amount of that support that is related to childcare. So if there is reimbursement, then obviously that wouldn't be part of it, but if there are some expenses for the childcare, then we would review that to see if that is appropriate. So, but as to the issue with the housing, that portion of the objection is denied, but we will prepare a new support recommendation based on updated childcare information. So Mr. Blumberg, if a friend of the court doesn't have that information, your client needs to supply that. Certainly we need to see what she's paying then for the food expense. And then we'll prepare a new recommendation. Any questions, counsel?
No, Your Honor.
No, we don't.
All right. Thank you. You're all set on this matter. We'll call the matter of Michael Fable versus Cara Fable. This is your motion, or your motions, correct?
Correct.
And what are you looking to change?
Right now we're in have split custody. I like to change it to full custody. And also change the child support.
Okay. And ma'am, are you in agreement or disagreement with that request?
Well, I thought we was doing 50-50, and the reason why we're not doing 50-50 because right now I don't have a place right now. And I thought that maybe he can do the full custody, and maybe when I get a place, we can do the 50-50 again.
The mom stands firm with solid facts, and when the judge reviews it all, she shuts him down completely. Proving hardship isn't always a free pass.
All right. Sir, what are your thoughts on that as a agreement?
That was pretty much what we agreed on, is giving me full custody until she can get her place together and we can relook at the situation.
Well, when you say look at the situation, so would you agree that to go back to 50-50 once she has an appropriate residence established?
Yeah, I told her we'll definitely look into that when that time comes, when she gets her place.
All right. So I've got to, make a decision on whether or not I can put together an order that reflects what the parties are requesting. She's indicating that once she has that, she wants to go back to 50-50. You indicate we'll look into it. So it sounds like you have some stipulations on going back to 50-50.
No, not really. It's just I just want to make sure that she has a place that will be suitable for the kids.
Sure, no, that definitely makes sense. Okay. All right, so I do think then we have an agreement. So sir, I'm going to start with you. Would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. And sir, is it correct that you're asking the court to enter an order that would indicate you would have the full physical custody at this time, and once Ms. Fable has an appropriate residence for the children, you would return to the 50-50 custody?
That's correct.
Okay. And do you believe this agreement is in the best interest of the children?
Yes, I do.
So at this time, then there would be no overnights with mom, is that correct?
That's correct.
Okay. All right, ma'am, would you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
Ma'am, are you also asking the court to enter an order that would grant Mr. Fowle the full physical custody, but once you have an appropriate residence for the children, the two of you would return to the joint physical custody?
Correct.
All right, thank you. You can put your hand down. And do you believe this agreement is in the best interest of the children?
Yes.
All right. And so they are with him full-time currently?
Yes.
All right, so if that's the case, I would also grant the request to modify the support. How long have they been with him full-time?
Since the beginning of the divorce.
Okay. So I can only go back as far as the support motion. So going back, so since it looks like you filed your motion July 21st, they were with you full-time at that point, sir?
Yes.
Okay. All right, so we'll adjust the support to no overnights for mom beginning July 21st. It's important that once the 50-50 custody is reinstated, that you let the friend of the court know. I'll indicate that once it is reinstated to 50-50, then the support recommendation would be amended to include the equal overnights. Any questions, sir?
Nope.
Ma'am, do you have any questions?
Yes, I do actually.
Okay.
So can I still like see the boys, like spend time with them? Like have them like come to me like for a day, like for a few hours and stuff? And like,
Can you guys agree to something? Do you want something specific, or as the two of you agree? Or sir, are you going to allow that type of parenting time?
Oh yeah, I got no problem with that.
All right, so ma'am, are you comfortable if we just say parenting time as the parties agree, or do you think you need a specific schedule?
maybe do to agree.
All right, so we'll indicate that parenting time for mom would be as the parties agree. All right, anything else?
No.
And do we have an appropriate mailing address for everybody? Friend of the court, do you need any additional information?
I would need to see where the defendant can receive mail. We would need that either on the record or potentially in writing. If
Okay.
she doesn't have a resident, she potentially could check with the post office, as there is some options available for getting a PO box.
Ma'am, as far as your mailing, where should we send that?
Well, I've been doing it at his house because it's closer for me to get to that house.
Okay. Sir, are you okay if the mail continues to go there and she gets it from you?
I'm hoping that she can get a PO box or something.
I just don't have the money for a PO box.
All right. So sir, is
All
she
right, well,
allowed to use until she has an address?
until she has an address, yeah, she can use the mailing.
All right, so we'll continue to send notices there, but ma'am, once you do have an address or get a PO box, make sure you let your caseworker know. Any other information needed by friend of the court?
Just are we doing a new support recommendation, or are we just going to no support? There is state assistance that I believe that the plaintiff is receiving.
Well, I think we're switching it to reflect no overnights for mom. So sir, you're requesting support just that the overnights be changed, is that correct?
Actually, I'm requesting at least zeroing out the support for now, at least.
You're requesting at least what?
To stop paying support for now, since I'm gonna be getting full custody of them.
Well, typically what we do is we recalculate it, so it would then be based on her having no overnights, which would likely result in some type of support payment to you.
Okay.
Are you not requesting support from her?
Oh, no, I'm not saying that. I'm just seeing
Okay.
exactly how that's playing out as far as switching
All right, so
from.
we'll do a new calculation based on mom having no overnights, and then you both will have the right to object to that recommendation if you don't think that's appropriate, okay?
Sound good.
All right, thank you. You're all set.
Thank you.
The matter of Naomi Griffin versus Jonathan Griffin. Ms. Griffin, you're the plaintiff, so I'll ask you first. Do the two of you have any agreements at this time regarding custody, parenting time, and support?
No, we do not.
Okay. Would you like to participate in mediation to see if you can reach an agreement, have some additional time to discuss the matters to see if you can reach an agreement, or set the matter for an evidentiary hearing, and then the court can make a recommendation after taking testimony?
Sorry. Well, I think that because I mean I'm in Michigan and he's in Tennessee. So I mean we've just kind of been doing video calls, and I think we're just both kind of in agreement. I think with everything.
All right, so he would have no in-person parenting time, just video calls?
That is correct. And neither one of us are kind of able to really financially do in person. So.
All right, Mr. Griffin, let me get your thoughts on this matter. What are you seeking as far as custody and parenting time?
It's pretty much exactly what she said. Neither one of us are able to financially do like in-person parenting time. We're only able to really do like virtual parenting time.
All right, and the kids are with Miss Griffin, is that correct?
Yes, sir.
So are you asking me, sir, then to enter an order that would grant the two of you joint legal custody, physical custody to Miss Griffin, and then parenting time as the parties agree?
Yes, sir.
And is it anticipated then at this time you're not going to have overnight visitation?
Yes, sir.
Okay. And Ms. Griffin, are you in agreement with that?
Sorry. I am, but I thought we had talked previously about him possibly just signing his rights away. I mean, I'm fine with either. We had talked, that was something that we had talked about.
Are you asking then for sole legal custody at this time?
Yes, sir.
Mr. Griffin, are you in agreement with, I had phrased it as joint legal and sole physical, but sir, are you in agreement that Ms. Griffin would have sole legal and sole physical?
Yes, sir.
Okay. All right, so Ms. Griffin, I will start with you. Would you please raise your right hand? Are you able to get your video going also?
I don't know how it gives me the option to talk for like I have to press a button to talk, but then it says that my video is stopped. I'm not sure how to do both. Oh wait, I got it. I'm sorry.
No problem. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. And ma'am, is it correct you're asking the court in agreeing to enter an order that would grant you sole legal and sole physical custody of the children?
Yes, sir.
And parenting time for Mr. Griffin would be as the parties agree, is that correct?
Yes, sir.
And do you believe this agreement is in the best interest of the children at this time?
Yes, sir.
And Mr. Griffin, if you could please unmute and hopefully get your video going. Would you please raise your right hand? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
And sir, you also asking the court then to enter an order that grants that grants Miss Griffin sole legal and sole physical custody of the children, with you having parenting time as the parties agree?
Yes, sir.
And you believe this agreement is in the best interest of the children?
Yes, sir.
The judge finalizes their heartfelt deal and even allows flexible visits, showing that sometimes love means stepping back for the kid's best interest.
And then Miss Griffin, as to child support, have the two of you had any discussions regarding that?
We have, and he is not really able to do much as far as child support. I'm receiving state assistance, so I mean, I'm I'm used to kind of like where I'm at, taking care of them financially anyways. I mean, I'm fine with whatever he's able to do, really. I don't want to put him in a hard spot, basically.
Do you want the court to prepare a child support recommendation that would then get potentially entered, but would give the parties a chance to object if they don't agree? Or would you rather just an informational support that would not become an order, but you would see what a calculation would look like, where the parties always have the right to seek support?
We can.
Well, there's assistance, so I have to do a support order of some sort. So he's gonna have to make some payments based on the fact that the children are receiving state assistance.
Okay.
There's additional support that can be calculated into that figure. Are you seeking support in this matter or not?
No.
Are you making that decision freely and voluntarily?
Yes.
And do you believe you can adequately care for the children without the receipt of support from Mr. Griffin?
Yes, sir.
All right, so there is assistance, is that correct, front of the court?
There is.
All right, so we'll prepare a support recommendation that deviates to the medical only. Is that your agreement then, Ms. Griffin?
Yes, sir.
Okay. Mr. Griffin, any objection to that?
No, sir.
Okay. And in front of the court, do you need any information from the parties?
I do need both parties' information, but as we're deviating to the medical, if they could reach out, I could ask them some questions to be able to do that. I do also need to get a legal address for the defendant. I don't know if the court could order with contact with him that we update that.
All right. Sir, do you want to call the front of the court and provide your address, or do you want to provide it on the record right now?
I can provide it on the record right now.
Okay. All right, so what is the correct address for you?
My address is 450 Airport Road in Shelbyville, Tennessee.
Okay. Area code 37160.
Yes, sir.
All right, so I'll have front of the court update that address information. You both do need to reach out to your caseworker. She does have court this morning, so I ask that you would call this afternoon or sometime this week. But you need to reach out to her to provide her some additional information so that that support recommendation can be prepared. Any questions, Ms. Griffin?
Yes. So I'm actually in the parking lot right now, and I have a whole stack of paperwork. What do I need to do with them? And also, as far as, I guess, a finalization date for the divorce itself, when would that be?
All right, so I can only handle the custody and parent time and support matters. Likely we'll get or have gotten a date then with Judge Hesselink. If that hasn't happened yet, that'll probably get scheduled here shortly.
Okay.
But so you'll go in front of the judge to finalize ultimately all the other terms of the divorce.
Okay.
She can submit her information at the counter. If I need additional, I can reach out.
Yeah, if you have that paperwork, ma'am, you can bring that on in to the front of the court. And they'll take that from you. And then if your caseworker needs some additional information, she'll give you a call, okay?
Okay.
All right, thank you both for appearing. You are free to sign off.
Thank you.
Thank you.
This is an initial hearing on a custody matter. Mr. Jester, do the parties have any agreement at this time?
No.
All right. So, Mr. Jester, when it comes to custody and parenting time, what are you?
What was that?
What type of custody and parenting time are you seeking?
I would like to go for back to the 3 days on, 3 days off, so I can maintain my full work week schedule, as well as I'm enrolled in college for the spring.
All right, and Ms. Doobie, you're in agreement or disagreement with that?
Disagreement.
All right, and what type of custody and parenting time arrangement are you requesting?
I want full physical and full legal. I'm willing to give him every other weekend to make sure that JJ gets the medical stuff that he needs correctly.
Okay. And sir, you're not in agreement with that?
No.
Okay. So there's a couple different options. We can refer the parties to mediation if you think some discussions might reach an agreement. If not, we would set the matter for a court hearing. Both present your arguments and then the court would make a recommendation.
I would like to go to court.
Okay, fair enough. We will set the matter for a court hearing. Ma'am, do you intend to call any witnesses or just provide your own testimony?
The only witness would be my boyfriend, since he was part of this, the whole like videos and pictures and everything.
I just asked because it determines whether or not I set it for a 1 hour hearing or a 3 hour hearing, depending on how much, if there's going to be witnesses or not. Sir, do you intend to call? I'm sorry, I missed that.
I do have a witness.
Okay, one witness or
I have, what was that?
One witness or multiple witnesses?
Just one.
Okay. All right, so I will set the matter, I think, for an hour. If we need more time, we can address that, but we're able to get through it in that time frame. So my next hour is November 19th at 11 a.m. Do either of you have any conflict with that date?
No, I do.
Is there any way that I can work out to see my son at some point? Because I have not been allowed to see him in 3 months.
I have to have, unless the parties reach an agreement, I have to have a hearing to determine the parenting time schedule. It sounds like Ms. Doobie might be okay with every other weekend pending the hearing. Is that correct, ma'am, or not?
No. Nope. I'm not gonna risk my son's medical stuff.
Okay. You said you were not available November 19th, ma'am?
I am.
Okay. How long has it been, sir, since you've had any parenting time?
3 months, 10 days. She has not allowed me to see him, text him. She won't let me video chat with him, nothing.
Can I note that he did see his son at one point, and his son wanted nothing to do with him. He was screaming, he was crying. So that's another reason that I do not want to put my son in that situation where I know he's not going to enjoy it at all.
All right. I mean, perhaps too, you could find some way to do some time together, either supervised or find a way to have your child be more comfortable. But if you guys can't reach an agreement, then that's, the court will have to make a decision. But I do have potentially, I guess, there was one slot that I was keeping in case something else ran over, but I think given the situation, we could use October 15th at 3 p.m. Either one of you have a conflict with that date?
1 second, let me check my calendar. Oh. What day was it? October
15th?
15th? That'll work. Yep. Will we get something in the mail confirming it?
Yes,
And all
you'll
of the
get a
things?
written
Okay.
notice. Sir, do you have any issue with October 15th at 3 p.m.?
No, sir.
All right, so we're gonna set the matter for the evidentiary hearing October 15th at 3 p.m. That is a in-person hearing. If you intend to call any witnesses or provide any exhibits, you do need to file a witness and exhibit list. 14
Would you
days.
get that from Friends of the Court?
Yes, they do have
Okay.
forms that you can use, and the notice that you get will have some additional information regarding that. All right, thank you both for appearing. I'll see you back here October 15th.
Thank you.
Thank you for your time.
Thank you. The matter of Aubrey Haskell versus David Haskell.
Zach Backlund on behalf of the plaintiff Aubrey Haskell, who's also appearing by Zoom, Your Honor.
Elliot Plumberg on behalf of David Haskell, who's appearing from my office via Zoom.
Thank you. And Mr. Blumberg, it's my understanding this is your motion for some credit for payments. Is that correct?
Yes, Judge. My client has received a notice from the state talking about a past due support obligation of $1,860. We have provided to the friend of the court a pretty detailed breakdown of all the payments made. And my understanding is the issue is payments made since November. My client has not only made all the payments, he's paid more than what was ordered. So we don't believe there should be any arrearage at this point.
All right, Mr. Backlund asked you credit for payments.
Certainly, Your Honor. This is something that we've been going back and forth on since about May, because there is a spousal support and a child support order in place. There's an agreement regarding the spousal support, which was determined by Judge Mertz. And so the parties utilize a joint account into which the defendant puts funds. And so there has been back and forth between Mr. Blumberg and I regarding what counts toward the support or what might not count toward the support. And we were working on the spousal support side of things with Judge Mertz. But it was not until recently that we finally had a child support order in this case. And so Judge Mertz was unable to determine how much arrears there would actually be before we actually knew how much credit to give. And on that side of things, I'm not sure if it made it to the friend of the court's file. I believe Mr. Blumberg and I both provided, we provided proposed omissions from that list because we had a ledger going back to June of 22 through May 7th of 2025. And so as part of our argument, we indicated on that list what we didn't believe should count toward credit of the arrears. And I know we're about 4 months removed from May, so certainly that has changed a bit. All that is to say, Your Honor, we've had some back and forth, and I believe Mr. Blumberg and I both spoke with Shasta and Dawn this week too about what we believe the arrears to be. And so all that is to say, there was about $35,000 deposited into the account over the last 3+ years. There was $10,000 of which on our list we said shouldn't count toward the arrears. So ultimately we need to figure out what the total amount of arrears were and then how that credit is being allocated between the child support and the spousal support. And I know the spousal support goes beyond what we're here to talk about today, but I think the big picture might be helpful here to help the court determine where we need to go to wrap this one up.
All right, so it sounds like the parties agree there's some sort of credit. You're not there on a consensus on what that credit is. So I would set the matter for an evidentiary hearing. If you guys reach an agreement ahead of time, great. If not, we'll hear arguments on what that credit should be. My next available time is November 19th. At 11 a.m. Any scheduling conflicts for the attorneys?
Yeah, I just got a trial notice. Hold on, if you could give me a second.
We'll set the matter then for an evidentiary hearing on what the amount of credit should be. December 3rd at 11. Gives the parties lots of time for discussions to see if you can reach an agreement. If you do, just please let us know.
Very good. Thank you.
Thank you.
Thank you. All right, this was set for a hearing to place an agreement on the record regarding child support. Do the parties have an agreement?
Yes.
All right, what is that agreement?
That the child support go to 0 and I pay the medical for Bryson.
And sir, is that your agreement?
I had signed the paper, but I don't really agree with that. I'd rather have a relationship with my son over getting paid.
Hold on, you broke up a little bit. So you do not agree to reducing it down to 0?
It can be, I've tried to reason with her, get it lowered and reduced, and it all comes to 0. And
All right,
just
so all
the
I'm asking you,
constant
sir,
harassment.
hold
No,
on. Hold on. There is an active custody order or support order. Where she pays you, looks like $475. Are you, she is indicating the two of you have an agreement to drop that to the medical only, which means you would not be receiving any support. You are free to make a decision on your own. I want your decision to be your own. I want you to make it freely and voluntarily. So my question for you is, are you in agreement in changing the support or not in agreement?
Not agreement.
Okay. All right, since there is no agreement, then the support will remain the same. Thank you both for appearing.
The final stretch brings raw courtroom emotion. Virtual parenting agreements, custody battles, and one father's refusal to trade love for money. He chooses connection over cash, ending this session on a powerful note. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.